Hello everyone, welcome to the CIB W113 Law and Dispute Resolution Working Commission webinar entitled COVID-19 Construction Challenges Through a Legal Lens, UK and Australian Perspectives. The COVID-19 pandemic has disrupted construction industries worldwide. This webinar views the construction challenges through a legal lens from the UK and Australian perspectives and considers the way in which construction law is applied and modified in response to the COVID-19 impact. The topics examined include legislation, health protection, prosecutions and construction health and safety, case law and construction contract remedies. I am Dr. Andrew Agapew, a joint coordinator for the W113 Working Commission on Law and Dispute Resolution. And I'm delighted to welcome two leading industry experts from the UK and Australia who provide us with some insights into the challenges in the two jurisdictions. So firstly, Jennifer Charlson is a senior lecturer in the School of Architecture and Built Environment at the University of Wolverhampton. And Jennifer is also a coordinator of the W113 Working Commission. We also have Rebecca Dixon, and Rebecca is Head of Legal at John Beaver, Australia, a PhD student at Monash University, Vice Chair and Director of the National Association of Women in Construction, Australia, and Director of the Australian Gender Equality Council. Before we get into the session, I would like to just go over some of the Zoom etiquette, if that's okay. The session will be recorded, and we will be immensely grateful if you could mute yourselves and turn off cameras. There will be an opportunity to ask Jennifer and Rebecca questions at the end of the presentation. And so please post these questions through the Zoom chat pane. The presentation will last approximately 1 hour, leaving us with some time for questions, followed by some announcements from the CIB themselves. Rebecca, over to you.
Thank you, Andrew, and thanks everyone for coming along. Obviously this slide is about setting the scene. One of the comments that doesn't feature on our slide, which I'd like to make before we start, is about the publications, I suppose, to which we've had regard when we've prepared the content for this presentation. COVID-19, notwithstanding that it's been in our lives for 6 or 7 months, is obviously relatively new from an academic perspective. So a lot of our sources are what in the academic community is known as grey literature. So produced by government, academics, business and industry in electronic and print form, but not generally made available by commercial publishers or people who have publication as their core business. So a lot of what you see on the slide today comes from, for example, the World Health Organization websites and government websites in the UK and Australia. And we're hoping that webinars like this one will start to contribute to the academic material that's available about COVID-19 and in particular, obviously for this audience, the information that's available about the construction industry and in particular construction law. Jennifer's going to give us a little bit more detail to place this in context for the rest of our webinar.
Okay, on the 5th of January 2020, the World Health Organization indicated that there was an unknown cause of pneumonia in Wuhan, China. By the 11th of March 2020, the World Health Organization declared COVID-19 as a pandemic. Looking at the government responses for Australia and UK, Australia were ahead in that on the 13th of March 2020, Australia's Prime Minister Scott Morrison mandated restrictions, followed by UK's Prime Minister Boris Johnson on the 23rd of March 2020, who instructed everyone to stay at home except for very limited purposes. Those limited purposes included buying food and medicine, exercising once a day. Travel to and from work was permitted, but work from home was encouraged. A bit of a challenge for construction projects in that you don't usually have a project at home. We were advised to keep 2 metres apart, and police were instructed to issue fines and require a dispersal of gatherings. Sadly, there are ongoing infections and restrictions. The economic impact, including on the construction industry, continues. So I'm going to move on to an overview of the session, supplementing what Andrew said at the beginning. So Rebecca and I are going to focus on construction industry impacts and legislative change. Then we will move on to health protection, and coupled with that, construction health and safety, which is a key issue in the industry before the pandemic. As a solicitor, I'm always very interested in how regulations can be enforced. So we will look at enforcement and resistance. Then we will move on to construction case law. At these early stages, the case law is focused around operation of the court rather than decisions associated with projects that have been impacted by COVID-19. We will then speculate a bit and consider contractual rights and remedies for construction contracts. Then we will look into our crystal balls and we'll Rebecca and I will reflect on where we think, what we think will happen next. We have used a red rose and colour red to indicate the UK context, and a golden wattle with colour yellow to indicate Australia. We recognise that there are important distinctions between the UK nations and Australian states and territories, which we'll mention wherever possible when significant. Although Rebecca and I are experienced construction lawyers in our jurisdictions, this webinar is not legal advice. Instead, we are endeavouring to shine a legal light on the complexities of the consequences of a pandemic. So we're now going to look at the impacts on the construction industry. So as mentioned, on the left-hand side of the screen is the colour red, which is for UK, and on the right-hand side of the screen is yellow for Rebecca. So looking at the construction industry in the UK, I have summarised some I've summarised some statistics from the Office of National Statistics. As far as I'm aware, the construction industry was not given any specific instruction as to how to respond, but it was plunged into uncertainty. Each site then responded differently. Many of them shut down, uncertain what to do. And after a while, some of them either reopened or continued once the site had decided how to continue to work on site safely. So over to Rebecca.
The two yellow boxes on the right hand of the slide, obviously the Australian content. One of the early surveys that came out was conducted by Roads Australia, who is an industry body operative in the construction and largely infrastructure sector in Australia. Notwithstanding their title, they're preoccupied with infrastructure generally and not just roads. As the quote illustrates, the people who were surveyed, largely construction companies and the membership of Roads Australia, reported that COVID-19 was already affecting their capacity to deliver projects and create uncertainty about future project timing and funding. For those Australians in the audience, you'll be aware that I suppose two big issues facing our industry at the moment are number one, the question of whether risk allocation, particularly for government procured major infrastructure projects, is appropriate or too onerous and seeks to pass too much risk to contractors. And the second is about how projects come to market and how they're procured. I suppose though COVID-19 is the perfect stomping ground to ventilate those two issues because, of course, everyone has finally pulled the contract out of the bottom drawer of the filing cabinet to look to see who actually takes the risk for COVID-19. And if I can share an anecdote, my experience so far is that principals would like the answer to be contractors. I work for a contractor, so forgive any bias that I demonstrate through this presentation. The other thing that we're starting to see, particularly since the Commonwealth budget was announced in October, is that funding will be made available for projects that are sort of ready spaghetti and ready to go. So how they get brought to market when they might not be fully developed and whether that sees an increased use of relationship or alliance contracting remains to be seen. But nevertheless, the risk allocation and uncertainty about future projects are two big things. For projects that are in delivery, the second box is the kind of experience that projects are reporting. Certainly, and if I can share an anecdote again, I work for an international contractor which specialises in renewable energy projects. Our selling point, we believe, is that we can deliver those projects effectively, efficiently and economically because we benefit from a global supply chain. So we can have our design done by experts who have been building these projects for ages and ages overseas and procure the equipment, obviously from overseas. But given that Australia is an island, not a little one, but an island nonetheless, when a global pandemic hits and the world almost shuts down, obviously the things that we benefit from and that we bring to renewable energy projects kind of are thrown into turmoil. So certainly my experience on projects that I've been advising my company for are experiencing those things in the second box. So we will move on to talk about the kinds of legislative changes that have occurred in response to COVID-19 in the construction industry. I'm going to hand back to Jennifer to talk about those changes in the UK.
Thank you, Rebecca. As you can see from the beautiful red rose, this is the UK perspective. So on the 25th of March 2020, the Coronavirus Act 2020 was fast-tracked through UK Parliament to exercise emergency powers. The Act had three main aims. One, to give further powers to the government to slow the spread of the virus. Two, to reduce resourcing and administrative burden on public bodies. Three, to limit the impact of potential staffing shortages on the delivery of public service. You would imagine that this Coronavirus Act was the most important and significant legislation regarding the pandemic. However, this is a mirage. It is not true. The day-to-day significant restrictions are under other primary legislation which will follow. I'll hand you back to Rebecca to explain the Australian legislative change.
Thank you, Jennifer. Well, our government, I suppose, did not leap into a piece of coronavirus legislation quite like the UK did. Rather, Australia is a federation, so it has a separation of government between the Commonwealth, which is the whole of Australian government, and then there's a government for each state and territory throughout Australia. There's also local government, which I won't ignore, but they are not relevant for this presentation. There's no single instrument, a legislative instrument, that responds to the COVID-19 pandemic, and this is partly reflective of our federalist nature. What we have seen, though, is that the Commonwealth and each of the state and territory governments have exercised existing statutory powers which relate to emergencies and health protection. The result is that there have been so many things, and I say things on purpose because they take a variety of forms, which I'll talk about a little later. But I suppose the changes in the legislative landscape have been thick and fast since March 2020. To demonstrate my point, I'd like to take you to this website, and I hope that this loads so that you can see my screen. It may not, because I can still see my PowerPoint, but in any event, I am taking you, I hope, to the Federal Court of Australia website, which very helpfully lists all of the COVID-19 related legislation, including orders, directions, regulations and resources that have been issued under that legislation. Helpfully, this website distills that legislation into the Commonwealth and each state and territory government, I suppose. If I might show you just as an example, this is the list of COVID-19 related Commonwealth legislative instruments that have been issued. And I suppose for the lawyers in the audience, and even the non-lawyers in the audience, but those whose lives and jobs are touched by construction law, keeping up with these changes, even to just work out whether these directions and publications are relevant, is quite the task. I'm scrolling and scrolling while we speak, but you may be able to see on the right-hand side of the screen that I'm not even halfway down the page, and I'm not even into the Australian states and territories yet. So, as I say, keeping on top of these changes has been, yeah, quite the task, quite the task. I will close this now and hand back to Jennifer to talk about legislation, but particularly in the context of health protection.
Thank you, Rebecca. Right, this to my mind is a very key slide from the UK perspective. So firstly, health protection is devolved to the UK nations, that's England, Scotland, Wales and Northern Ireland, which explains why these different nations have had different approaches to restrictions in regard to the pandemic. So the first statutory instrument that I'm going to mention was on the 26th of March 2020 with the Health Protection Coronavirus Restrictions England Regulations 2020. This came into force immediately, and the Secretary of State argued that it was a proportionate response to the current challenges. Since then, there's been an avalanche of secondary legislation, and by the 25th of September, there were over 200 statutory instruments. There's not enough time to cover all of them in this presentation. However, they can be found on the government legislation website, which is www.legislation.gov.uk, and if you search for coronavirus, all these statutory instruments will appear before you. As Rebecca mentioned, navigating them is a tough challenge, not least of which many of the statutory instruments had a limited time, a limited life, and so many of them have expired to be replaced speedily with something very similar. So happy hunting on that website. You could be there for hours. There is also confusion between law and guidance, which is very significant in that guidance is very helpful, but it's useful to know whether you are going to come under sanction if you don't follow it, whereas law normally has legal teeth and sanctions. There has been some resistance or opposition to the regulations, which is growing. One of the earliest advocates to this stance was Lord Sumption, who's a former UK Supreme Court judge. On the 15th of May, he wrote in the Sunday Times, and this is a quote extract from his article. "It is our business, not the state's, to say what risk we will take with our own health. The lockdown is now all about protecting politicians' backs. They are not wicked men, just timid ones, terrified of being blamed for deaths on their watch, but it is a wicked thing that they are doing. There have also been 2 unsuccessful challenges in the courts. The first one, of the R brackets Hussein versus the Secretary of State. This was a challenge where a mosque was refused permission to hold Friday prayers during Ramadan. And then the second challenge covered a number of points, in particular the closure of schools. There has also been an investigation by the UK Parliament's Joint Committee on Human Rights, and their report said that the government should not have used health protection legislation. Instead, the following 2 statutes should have been used. Firstly, the Civil Contingencies Act 2004, or the Coronavirus Act 2020, as they have better safeguards. The opposition and resistance to the health protection regulations, rules and regulations is growing, and I'll talk a bit more about it later on. And I'll hand you back to Rebecca for the Australian health protection view.
Thank you, Jennifer. Thank you. So I mentioned earlier in this presentation that in Australia, what we've seen is the exercise of existing legislative powers, particularly in relation to emergencies and health. In each of the Commonwealth and Australian states and territories, declarations were made under existing legislation. I've listed them here and the dates that they were made. I suppose the benefit for government of giving one of these declarations is that it opened a gate into a whole raft of legislative powers that can be exercised, particularly in the making, particularly the power to make orders, directions, determinations and impose requirements in relation to those emergencies in health and safety. So the result of that has been, I suppose, to empower particular people who are named under the legislation. They have titles such as the Chief Health Officer, Minister for Health, Public Health Commander and so on, to issue orders, determinations and impose requirements. This little cartoon down the bottom, I feel like is me at work at the moment. My company is delivering projects right around Australia and in each state and territory, and really the mind boggles when you try to get on top of the determinations and declarations that are being made, particularly, I mean, with respect to some of them, we're up to sort of version 16 of the orders, requirements, determinations about how we all need to operate. The benefit of this presentation, I went looking for some of my colleagues in private practice to see who had summarised those helpfully for us, and they haven't sponsored this presentation, but they are my old firm, and the lead author is a very good friend of mine. So I was thrilled to find this, which I'm going to share now with you. I'm just going to try a different way to share that with you. So bear with me just 1 second so I can show you. Minter Ellison, which is a law firm in Australia, has helpfully published this guide about stage 4 restrictions in Victoria. So obviously only in relation to one of the states and territories, and it was published not that long ago on the 12th of August 2020. The purpose of the document is to be a summary, but for those of you who are noticing the page numbers up here, you'll see it's 16 pages of text, which doesn't strike me as being a summary, but nevertheless, when you read it, it is a very good summary. And certainly it is a summary of the very, very, very many orders that apply to working in the Victorian construction industry. The very unfortunate thing about this, I think, is that notwithstanding that it was only written a couple of months ago, it's already out of date because of this constant flux in the legislative landscape, particularly in Victoria. So for any of those of you who are in private practice who would like to publish something similar, we in-house lawyers welcome it wholeheartedly, because certainly, as I say, as I've mentioned before, with my little cartoon, the eyes boggle when we're, I suppose, faced with the challenge of, I'm just going back to my presentation, sorry, faced with the challenge of understanding day to day the requirements that our, my company and the project managers and the workers that turn up to work on an operative construction site every day, what they need to comply with. Speaking of construction sites, let's move from a, I suppose, general to, health protection conversation into the construction context, and to talk about construction health and safety. So I'm going to jump to the next slide and hand back to Jennifer to talk about that in the UK.
Thank you, Rebecca. So first of all, addressing the left-hand side of the slide with the beautiful red rose and red border. The main applicable act is the Health and Safety Act 1974, which continues to be applicable. Most health and safety regulations are made under this act or European Union regulations. English employers have a clear health and safety responsibilities under this act. Their duty is to undertake steps reasonably practicable to manage COVID-19 risks, which can be addressed by undertaking and implementing risk assessments. There isn't a particular amendment to this act regarding COVID-19. It just slots into the overall broad approach to risks. On the 11th of May 2020, the UK government issued guidance for the construction sector, and this included social distancing, personal protective equipment with which construction is very familiar already, and also face coverings. So over to Rebecca to talk about the Australian experience.
Thank you, Jennifer. I think in a piece of good news, the construction industry in Australia, and I don't expect the situation is too dissimilar in the UK, is highly regulated already, and it's very compliance focused. So I'm not, well, again, this is anecdotal evidence or stories that I've heard from our active construction sites, but one requirement or one piece of compliance is another piece of compliance. And if we tell our workers what they've got to do, they get on and do it. The fortunate thing about that, I suppose, is that on the whole, construction sites, particularly for non-residential building work, have continued to operate, but they are subject to restrictions. And as Jennifer mentioned earlier in this presentation, a plethora of guidelines. I'm channeling Jack Sparrow from the Pirates of the Caribbean. They're great movies, but which has been published by health and safety authorities. So creatures of legislation which have certain powers, and then publish this material. I'm going to try one more time to take you. I'm very grateful to Paula Gerber, who's dialing, my PhD supervisor, who's educating me on the use of Zoom while we're going, but I'm going to stop sharing my screen, jump to the last thing that I want to show you, and hope that I can share this with you. Bear with me just 1 minute.
So while Rebecca's doing that, I'll just mention that we understand we had over 160 people who signed up for this webinar. Hey, well done, it's there. And yeah, so we had 160 people signed up for this webinar. We're very grateful that you're all there, so welcome.
Yeah, no, I echo Jennifer's thoughts. Thank you. So I wanted to show you an example of the guidelines that have been issued by one of the authorities. These are the COVID Safe Workplace Guidelines issued by WorkSafe Tasmania. Every state and territory, I feel, has a WorkSafe in Australia, but this is the Tasmanian one. The recommendations or the actions to control risks are set out in the right-hand column of this guidance material, and the standard, which is mandated by legislation, the truest sense of the word, is set out on the left. All of this material on the right-hand side is obviously exceptionally helpful because it will give people who are bound by these standards a guide to how they can comply. But as Jennifer foreshadowed earlier in this presentation, the question then becomes, well, do you have to comply with the particular actions that are on the right-hand side, and do you have to do the actions in order to demonstrate that you're complying, or are the actions just a suggestion as to how you might demonstrate that you comply? Where the line becomes increasingly blurred is when the actions here, and I'm just going to do a little search to jump you to one because there are a few, but where the actions use the word must, so where they use mandatory language rather than sort of optional language. So here is a good example. The suggestion is to minimise the use of shared equipment and tools, but the mandatory requirement is that each worker and contractor must have their own gloves. Another one is here, so if workers are required to travel together, air conditioning must be set to external airflow rather than to recirculation or windows. So again, the question arises, well, are these mandatory or are they optional? Are they recommendations or are they not? I go on to talk a little bit about how parties might navigate through that trouble a little bit later in this presentation, particularly in the Australian context, but for now, I thought it would be useful to demonstrate to you all just what's out there, and that it's pretty detailed, and that it's not really as, notwithstanding that the authorities are trying to be helpful, they might not be as helpful as they think that they are. Jennifer, we're going to jump over to enforcement, but I'm just going to stop sharing this screen and jump back to our presentation.
Okay, as I mentioned earlier, as practicing lawyers, well, I was a practicing lawyer, I'm now an academic, we're very focused on what the consequences are of any action. So enforcement is a key concern for us. So Rebecca will move on to the enforcement slide, and we'll look at enforcement from a UK and a Australian perspective. So as before, I'm sailing under the red rose flag, as it were, and I'll talk about the UK perspective on enforcement. The Crown Prosecution Service reviewed the first 200 finalised cases up to the end of April. They did discover that the majority of prosecutions under the health protection regulations were correctly charged, but all cases, that's 44 under the Coronavirus Act 2020, were incorrectly charged. However, after this shambolic approach, the prosecution authorities did get a grip and have started sentencing people to prison. There are quite a number of cases of individuals sentenced to prison for 6 to 7 months. If you have a look on the Crown Prosecution Service website, you can find a whole litany of inappropriate behaviour involving, as you can see on Rebecca's slide, spitting and coughing on people. Also, I know that there's a number of students on this webinar. Now UK fines are up to £10,000, and recently 3 students were fined £10,000 each for holding a party when they should have been self-isolating. Over to Rebecca.
That's me. So in Australia, COVID-19 offences include failing to self-isolate, wear a face covering or a mask, breaching restrictions in relation to gatherings, and my 2 favourites, intentionally spitting or coughing on a public official or worker, which I was told by my brother-in-law, who was a police officer, has come about because people have been spitting and coughing on police officers, threatening to give them COVID-19 when they do sort of check to see if they're isolating inspections. So I'm a bit embarrassed about that. I'm almost more embarrassed about the last one, which is failing to wear an electronic monitoring device, which is an offence in Western Australia, and has been, I think, well, a requirement to wear an electronic monitoring device, I think, has been imposed once on a serial offender who continued to breach requirements to self-isolate after he was moving about. So these are serious things. The offences attract fines. The dollars I've listed are in Victoria. They're the highest I've found. So about $5,000 for a single offence and for $20,000 for repeat offenders. I'm going to jump to resistance, which Jennifer's touched on a little bit already. I know we haven't done that in Australia, but Jennifer, please tell us about resistance in the UK.
Of course, and this is a growing theme. So first of all, the Common Speaker has accused the government of treating Parliament with contempt. So at the end of September, Sir Lindsay Hoyle said the government is treating Parliament with contempt by rushing through new power to tackle coronavirus without debate. There has been a similar condemnation in the House of Lords, and we had some new lockdown regulations that came into force in England on the 14th of October. This introduced a 3-tier level of restrictions to address local outbreaks of COVID-19 with the criteria of medium, high or very high coronavirus infections. This is currently breaking news as to how they've been implemented. The first area that went into the very high tier was Liverpool, and a number of northern areas are also on the brink of entering tier 3. The current political controversy is with regards to Greater Manchester, and although the government does have the power to impose tier 3 restrictions, and indeed they are going to do that for Manchester, they are really on the grounds of politics are endeavouring to do so on an agreed basis. And the key issue is what financial support package is going to be available to support the areas as they go into tier 3. This is an illustration of the close connection between politics and law, and I'll just have a little political diversion and we'll come back to law. So broadly speaking, the UK government is a Conservative government led by Prime Minister Boris Johnson, and the party has an 80-seat majority in the House of Commons, which gives them a great deal of flexibility to pursue their own agenda. Whereas, sadly, the areas that currently have the highest infection rates are focused around the north of England, which ordinarily will have a more Labour political party focus. So what has opened is a political chasm between Northern England mayors who will often have a Labour Party affiliation and a central government based in London, which will have a Conservative party predominate. And we're now seeing the consensus between most of the politicians and members of the public is now fracturing. So I'll pass you over to Rebecca to talk about the position in Australia.
I think what Jennifer's described is certainly the case in Victoria. I'm going to focus a little bit on Victoria here. Victoria, for those who don't know, is the state in Australia that's suffered, and I use that word because I am a Melburnian, so I'm a Victorian, stage 4 restrictions for a long period of time, so since the 2nd of August 2020. To put that in context, there is no stage 5. So, and there seems to be a spectrum of things that the government will do within stage 4, but we are in stage 4. That's meant a restriction of a 5-kilometre radius in terms of travel. We've had curfews imposed on us, sort of limited reasons for leaving home. The upshot of that is, I suppose, a deprivation of being able to visit family and friends, and certainly, and colleagues, even for those who aren't permitted workers and therefore don't have a permit to go to work. The expectation is that you work from home. I mentioned earlier in this presentation that the trigger for imposing these types of restrictions was the declaration made under Victoria's Public Health and Wellbeing Act. In Victoria, the government, it's a Labor government led by the Premier Daniel Andrews, sought to extend the power to have that direction. Can only last for a finite period of time, but the government asked for it to be extended by 12 months. It has been extended by 6. 14 prominent legal figures who included retired judges and Queen's Counsel and Senior Counsel, I suppose, pleaded with government not to pursue that course of action on the basis that the approach was unprecedented, excessive and open to abuse. I understand, although I have not done the research, that the similar powers actually exist in other states and territories. So in many respects, this request for an extension of the power caught the media's attention because it was because we needed to extend it. Quite apart from those comments, there have been other challenges to enforcement measures and the restrictions generally. I read recently that of the fines that have been issued, about 2% in Victoria have been paid. Their work cover, which is the, or WorkSafe, which is the Victorian Safety Authority, has been conducting inspections, which they have the power to do, and issuing notices for improvement, which again, they've got the power to do under the Occupational Health and Safety Act in Victoria. And those improvement notices generally comment on actual behaviour against a COVID-safe work plan, which is required by one of the orders that's been made since the declaration of emergency. And those COVID-safe plans don't necessarily have any sort of statutory grounding as such. So it's the fact that an infringement notice can be issued off the back of them is sort of an interesting legal, I suppose, analysis, or gives rise to an interesting legal analysis. The two I'm watching with particular interest are constitutional challenges. Sorry, I'm aware of two. The first was made by Clive Palmer, who is an independent political member. There's a political context for his challenge. He and the Western Australian government aren't getting along at the moment, but he challenged the Western Australian restrictions on the basis of those restrictions in terms of cross-border travel that prevented him from coming to see his company operations. He owns a mining company in Western Australia. He challenged those on the basis that they were inconsistent with the Australian Constitution and the implied right to freedom of movement. A similar challenge has been made in Victoria by a publican in Sorrento, which is a beautiful beachside town in Victoria. The challenge, I suppose, is made on the same inconsistency basis. The restrictions in Victoria are inconsistent with the implied freedom of movement. The interesting thing about his case is that it also talks about the mental health impact of being isolated for such a prolonged period of time, which I'll talk to a little bit about further in this presentation. Unlike the government in the UK, I mentioned that our Premier in Victoria is not conservative. He was at least a very, very popular Premier, and is reported to have done very many good things for Melbourne and Victoria. But there are a lot of Victorians now who seem to be turning against him and are calling for him to be replaced and at least to resign. The allegations are numerous, but they include misusing health advice and statistics, I suppose contemplating the step down of stage 4 restrictions on the basis of case numbers and death numbers that will never be achieved, and then acting against the World Health Organization recent recommendations not to use lockdowns as the primary way to stop the transmission of COVID-19. So, yeah, it remains to be seen, I suppose, what happens in Victoria. In other states and territories, I mentioned Western Australia with the Clive Palmer challenge. There was something similar in Queensland, but otherwise the states and territories in Australia, other than Victoria, have been fairly quiet. I expect that's because New South Wales, South Australia, Tasmania, the Northern Territory seem to have clamped down on case transfers quite quickly. And indeed, the ACT hasn't reported a case of COVID since July. So, yeah, different experience in those states, but where the experience has been a bit more COVID case heavy, we've seen a different response. We're going to jump over the construction case law, Jennifer, and you've got a much more interesting report than me on this, so I will hand over to you.
Oh, thanks, Rebecca. Although the slide is titled Construction Case Law, it's probably better to provide it as case management. Because these are these cases are around how the cases are being managed by UK Technology Construction Court judges. So the first case, Milchrist, the contractor sought an injunction to prevent progress of an adjudication, arguing that it would have insufficient time to prepare a defence on the basis that the solicitor was self-isolating and no representative could join the site visit. However, the judge was not sympathetic to these arguments and said that the solicitor could be contracted remotely and the site visit could be recorded. And she concluded that natural justice was not inevitably to be breached and refused the injunction. The second case arose out of the Fundão Dam in Brazil, which collapsed, releasing large quantities of toxic material. The judge did adjourn the hearing date, but relisted after a short delay. So technology and construction court judges are very keen for swift progress of litigation. However, Rebecca and I are waiting the outcome of litigated COVID impacted construction projects to see how the judges are going to undertake the very difficult challenge of how to allocate the consequences of COVID-19 pandemic on contractors and employers. Over to Rebecca.
Well, I think that's right, Jennifer. I think there will be a few, or you and me and a few in the presentation listening in, that are waiting for a juicy disputed extension of time and delay costs claim about COVID-19. So watch this space. That leads us nicely into a discussion of contracts, construction contracts, and we're going to break with the pattern, and I'm going to go first on this one and talk a little bit about the way that construction contracts work in Australia. In Australia, there is a standard form suite of construction contracts produced by Standards Australia, and we really haven't caught up with the rest of the world and I suppose started benefiting from the use of the FIDIC suite or the JCT contracts. So a lot of our contracts are either bespoke or standard form, Standards Australia standard form contracts. None of those in there, well, not obviously ignoring bespoke contracts, but none of the Standards Australia standard form unamended contracts include force majeure regimes. And therefore, where contracts do, they are created by the contracting parties and slotted into the contract as an amendment. Therefore, there's no standard definition of force majeure event, and there are no standard preconditions for relief. However, when contracting parties agree to insert a force majeure regime, it's usually a precondition that that event has, the force majeure event has caused an impact to the critical path of the construction project program. There isn't something else going on at the same time for which the contractor isn't entitled to an extension of time, so there's an absence of concurrent delay, and there are usually preconditions around timely notification, so time bars. The former Justice Peter Vickery, who was the judge in charge of the technology, engineering and construction list in the Victorian Supreme Court, has written 2 papers, both of which he presented to his old law school at the University of Technology in Sydney. He has advocated or suggested that it's time, and that circumstances like this justify the introduction of a statutory amendment that would see contractors have some relief from COVID-19. That paper, I haven't seen anything done with that paper, but certainly as a contractor, I know that when we entered into the contracts, I don't think that the principal or the employer could say this either, but I don't think that any of us anticipated that we'd have a pandemic like COVID-19 or that it would have quite the impact that it's had. I quite like Justice Vickery's suggestion. What am I seeing, and what can I anticipate is going on? I have a feeling that if parties didn't specifically turn their mind to pandemics, so such as SARS or the SARS regime, that definitions of force majeure event might exclude the COVID-19 pandemic and its consequences. The challenge then, of course, is to try and squeeze COVID-19, all the things that have happened since, into a force majeure definition. I think because COVID-19, the pandemic and the outbreak, has then caused a whole raft of other things to happen, proving causation, so linking the particular construction industry impact back to a pandemic, if that's the event nominated in the force majeure definition, is difficult, especially when there are many, many things in between that could have been the causative event. I mentioned grey literature at the beginning of this presentation. what has been very helpful is the number of law firms who have commented on COVID-19, the application of construction contracts, construction contract remedies and so on. There's been a lot of material published about the doctrine of frustration. For those playing at home, the doctrine of frustration applies to rescind a contract when performing it has become so materially different to what the party, or radically different to what the parties intended, that it becomes impossible to perform, or remarkably or radically different to what they intended. Generally speaking, changes to a program and incurring more cost to do the work, so the cost of performance increasing, don't reach that very high threshold required to establish that the contract's been frustrated. Most of the law firm commentary that I've seen has recommended against pursuing frustration and instead focusing on other contractual regimes like force majeure. Jennifer and I have both talked about changes in law and in particular guidelines. In Australia, construction contracts define law or legislative requirements. So in terms of seeking relief for compliance with mandatory guidelines, the challenge then becomes quite like the challenge for force majeure and squeezing those guidelines, orders, determinations, requirements, whatever they're called, into the definition of law that appears in the contract. Certainly in Australia, that's an attractive option for contracting parties because changes in law often give you time and cost relief, whereas the force majeure regime in Australia tends to allocate the risk of time to the principal, so the contractor is entitled to an extension to the date for practical completion or the date for commercial operation, but they won't be entitled to the costs incurred as a result of that delay. So for the front-end lawyers and the middle-end contract administration lawyers, there's some challenging contractual interpretation matters, I'm sure, on your desks. There certainly are on mine. And for those of us who don't like, or who aren't practicing disputes lawyers, the challenge is to sort them out sooner rather than later, I imagine. Jennifer, over to you for comments about the UK and the construction contract context.
Okay, thank you, Rebecca. From the UK perspective, proving causation is going to be a significant challenge as well. Also, the frustration threshold is very high. Most projects can be delivered, but are going to be delayed and much more expensive. We do have some pre-existing case law on a frustration, which was the Eugenia in 1964, a Lord Denning decision regarding when the Suez Canal was closed. And the decision was, although the shipping now needed to go around Africa, the contract wasn't frustrated, it was just merely more expensive and took longer, but the actual contract could be delivered, which I suspect many construction projects are going to be in a similar circumstance. In the UK, the Joint Contracts Tribunal, JCT, has published articles about using JCT contracts in England and Wales. The articles include one considering what should happen about contracts that have been entered into prior to reasonable foreseeability of the effect of coronavirus, and discusses the impact of the virus on government action, speculating that it could result in extensions of time, suspension of the work, or possibly the termination of the contractor's employment. A later article talked about the COVID context, the government's response, and reflected on the Construction Leadership Council's site operating procedures. Build UK has also published some guidance. But in summary, we are really awaiting judicial precedents as to how contracts are to be interpreted in the COVID-19 context. Sadly, I don't think there's going to be any winners on these sorts of decisions, and I think that the judges are going to have some very difficult decisions to make. So I'll move on to observations. So COVID-19 pandemic has had, and perhaps more surprising in that there was some hopes that after initial lockdowns we'd be able to return to normal life, and that is just not the case. If anything, certainly in the UK, the situation and also Europe seems to be getting worse. So it's had an overwhelming impact on global economies, including the construction sector, and this has caused unprecedented uncertainty. It's a really difficult time to make decisions, and I have tremendous empathy for those currently practicing solicitors. I was an in-house solicitor like Rebecca for a major construction company for 9 years, and I recognise that there must be incredible pressure on businesses to try and decide how best to proceed. There are ongoing restrictions under existing legislation, primarily in the UK under health protection, and it seems that under Australian that's under the category of emergencies. So far, there have been unsuccessful legal challenges, opposition and criticism, but this hasn't really translated to any specific action or outcomes yet, but we are waiting to see what they're going to be. There has been enforcement of particularly the health protection or equivalent regulations, including imprisonment and fines. Judges are endeavouring to progress cases swiftly, and I've been listening this morning, and there's a particular impact on the criminal justice system in that many criminal trials have ground to a halt or not proceeded. And then our last bullet point is probably the most pressing one for the construction industry, is how construction contracts are to be interpreted and applied. There's basically, the industry is in a state of lack of clear direction, and judicial decisions of how contracts are to be interpreted are anticipated, and hopefully they'll give the construction industry some guidance on how to proceed. So over to Rebecca for a bit of crystal ball gazing.
So yes, in light of the presentation, where do we go from here? I think the message that we can take from especially the observations that Jennifer has made in our presentation is that the legislative environment is going to continue to change and be in a state of flux, particularly as we see, as you've mentioned, Jennifer, countries around the world experiencing second and third waves of COVID-19. Certainly in Victoria, we had our second wave, and the lockdown response was so much stricter than the first. So that's I suppose, watch this space. The impact on businesses, is unpredictable, I think, especially when the COVID cases aren't under control. I think the pleasing, I use with some caution, but the pleasing news for construction lawyers is that there's plenty of work to do, particularly to make sure that clients are aware of their current compliance obligations in relation to the law when it changes every day. I remember asking a law firm I'm briefing at the moment to prepare a memorandum about changes in law in various jurisdictions that were relevant to a project. That memorandum jumped from sort of 8 pages to 108 pages, super fast. And I think that is demonstrative of just how often the law is changing and how much work there is to do to stay on top of it. I suppose the other strange thing is finding the law. Like for the first time in my career, I don't jump straight onto Vic Legislation's website. I jump to the Department of Health websites throughout the country. So again, there's always, good news, bad news, there's always work for construction lawyers. I think the other thing that we might see is, irrespective of contracts, we might be advising our clients on commercial conversations supported by contract interpretation, talking to their clients about relief, or clients talking to contractors about contractual relief. I think the reality is that COVID-19 is having an impact on construction projects, and how the loss falls once the contract is applied, and the risks are transferred, I suppose, remains to be seen with any luck. I mean, I hope, as a non-disputes lawyer, I hope that we don't get the jurisprudence that Jennifer foreshadows, but I suppose it would certainly be helpful if pandemics like COVID-19 continue to occur. What's next for us? I mean, with the information that we've presented to you today in a more detailed form, we've prepared a draft article for publication in the International Construction Law Review, which we hope is accepted, and that we hope is somewhat of a foundation article to set the scene for what's been going on in the UK and Australia in terms of the construction law impact of COVID-19. And Jennifer, without making any promises, I think our plan is to continue to watch these spaces and update our foundation article as further developments that might be of interest to the audience when they arise.
Yes. Yeah. So I think we've reached the point that we're going to open ourselves to questions to be shared by Andrew. I feel a bit nervous about saying we're going to answer questions because I don't think anybody really knows the answers, but nevertheless, if Andrew would like to pose the questions, and we'll do our best to answer, but like everyone else, we're still trying to grapple with the uncertainty. Thank you, Andrew.
Thank you, Jennifer and Rebecca, for your insightful and well-timed presentation. I have some questions which have come up on the chat pane. So for the purposes of the recording, I'm just going to read them out as they've popped up, and we'll hopefully get a few more. Right, start. First one. What changes do Rebecca and Jennifer see in construction contract negotiations going forward? And do you think it will end up with the risk allocation?
Well, I'm happy to take that one first, Jennifer, if you like, from the Australian perspective.
Thank you.
No, it's okay. I remember a few years ago now, the Brisbane River, which is the main, well, it's a river that flows through the middle of Brisbane City, flooded. And after then, force majeure event definitions suddenly picked up on flooding, and everyone was talking about the frequency of flood events. So I firmly expect that the words pandemic may work their way into force majeure definitions. Whether or not they're accepted, I don't know. I'm hopeful that they will be, because the reality is that no contracting party can manage and control, I suppose, a COVID-19 type pandemic on a construction project. So how the parties strike their preferred risk allocation, I'm not sure. I fear that, well, I feel that this event may end up in force majeure so that risk is shared. I think it's unlikely that we'll see a risk transfer where, say, an employer holds time and cost risk for an event like COVID-19.
Okay, thank you, Rebecca. A bit like Rebecca, I tend to view the world through a pair of construction contractor glasses, because my experience has been on the contracting side of the world rather than the employer side of the world. And as Rebecca indicated, I think these sorts of risks are either going to be shared or sadly head towards the contractor. I guess the sort of culture of contracting or construction industry does tend to be that the employer will endeavour to pass as much risk down to the contractor as they possibly can. Okay, Andrew, next question.
Oh, you're muted, Andrew. Would you like to pop your microphone back on?
Thank you, Rebecca. One of the hazards of using Zoom. So next question was quite an interesting one. do you think COVID-19 is a natural disaster or a man-made disaster? And what's the implications of either one?
I'll go first on this one. In terms of what the implications are, I can give my wonderful lawyer response, which it depends. So it really rather depends on how the contract is drafted as to how this event fits in. In terms of whether it's a natural disaster or a man-made disaster, I'll do a hospital pass over to Rebecca and she can speculate on that one.
Well, I'm going to give you another lawyer answer, but I've certainly done my best to argue that it's both, depending on what the contract says. If I've got one contract that says it's a national, like I get relief for natural catastrophes, I'm squeezing it into that. But if I've got another one saying man-made, I don't know, disasters, then I'm squeezing it into that. What it actually is, I think, Andrew, is a question for the scientists, and I won't profess to be one of those. So I'm not sure that really answers the question, but Jennifer, we are both lawyers. We've given the lawyer answers.
Maybe a kind of supplementary for me that might be helpful. Have you come across any jurisdictions where there is a definition of a natural or a man-made disaster has been force majeure? Would it have to be written in the law?
I haven't looked in that detail yet. What we were endeavouring to do with this piece of research and presentation is to just set the scene, because everything was just so uncertain. So what we've tried to do is put down some markers as to what we think is relevant, and then this will be later hopefully built on probably by us and perhaps others as to this sort of level of detail. If you've got any wisdom to share with us, Andrew, we'd be pleased to hear.
Well, I was quite interested while you were talking, Rebecca and Jennifer, to read about NEC4 and how they deal with compensation events. So you'll be aware there's many more compensation event claims possible through NEC4. And I was reading the secondary option X2. There's the secondary options that you can get. And I'm just kind of quoting, saying that a change in the law gives entitlement to time and money, which is quite different from, I think, the JCT contract or the SBCC contract in Scotland. Any views on that?
Yes, me. I'm probably more familiar with the NEC contract than Rebecca. And I think the key to this is, you said it's a secondary option X2. So it's only going to apply if it's been incorporated into the contract. And by your reading of that, it sounds as though it's an option that is favourable to the contractor. So I'm a bit cynical as to how many contracts have actually had that incorporated.
Okay, fair enough. Can't see any further questions. I know the system went down for 1 or 2 seconds, and I think I lost one of the questions. So if anyone's got any further questions, could you please post them? And I'll put them to Rebecca and Jennifer. Yes, right, got it. Given construction will be used to start economic recovery at construction firms are construction firms in the best place to get changes to typical risk allocations with government?
I certainly hope so. I'm probably optimistic or naively optimistic, but if there was ever something that was this disruptive, well, certainly in my lifetime and in my career to the construction industry, it hasn't been this disruptive so far. And if I mean, there's been the expression that Australia is going to build itself out of a recession, and if if that's the case, then the time is now. I mean, before COVID-19 hit, the tier 1 contractors in Australia, such as John Holland, had, I remember the CEO of John Holland, Joe Barr, came out and said, we're not going to bid these projects anymore. He was talking about public-private partnerships, which really aren't partnerships at all, because they are, as Jennifer said, a transfer of all risk to government, which they justify on the basis that the, I suppose, the equity provider and the contractor will see a financial benefit from doing the project, and the consideration they give is a whole of project risk assumption. The reality is, though, that those projects are bid at very low margin. The contract that goes out to market is I suppose, the best case scenario for government. And the task, you know, the response, I say this from experience, but the response when you raise a departure to that contract is, oh, well, just bid it back. But you don't want to bid it back because you lose, and then you're getting no money at all. So the situation is pretty dire, I think, and that climate for bidding projects and taking them on, only to see huge financial losses when the risks arise. I mean, there are 2 projects in Melbourne that are both PPPs that are forecasting insane losses, like billions of dollars worth of losses. So, I mean, they haven't seemed to have woken government up. I've got my contractor hat on now, so I'm obviously swaying to one political side, but they haven't woken government up yet. And I'm, I suppose, cautiously optimistic that COVID-19 might. I think the big difference between those PPPs and the projects now, though, is that they're coming into the market a lot sooner. So the level of information that government can provide about the project isn't as developed as it has been before. So they can't say to the contracting market, we've told you everything. You should know everything now. Go and give us your price. They're relying on the contractor working cooperatively and collaboratively with them to be able to develop the project. And I think when you go to market like that, you can't, those sort of hard, fast lump sum procurement models just don't work. So fingers crossed, Andrew, I'm hopeful.
It's of experience of advising on private finance or PPP contracts in the UK context, and it is a very significant risk transfer. At this point, I should perhaps reveal that my in-house construction experience was with Carillion, who then became insolvent. They were one of the top 4 contractors in the UK. I should perhaps say that this happened many years after I left, so it wasn't me. So in the same way as in Australia, there is a focus in the UK, political focus on the construction industry, and slogans like build, build, build come to mind, with a decision made before the COVID-19 pandemic was that the High Speed 2 project should continue despite the very significant cost. So there is definitely an aspiration to provide some sort of impetus to the economy through construction, and there is money there, but I'm a bit more less optimistic about shall I call it fairer risk allocation, so that there is money to be spent, but that doesn't mean it's a risk-free environment for contractors.
Okay, thank you, Jennifer. So kind of a follow-up related question. Is there an opportunity for construction firms to use COVID-19 as the reason to reset the commercial framework while still completing the project?
I hope so, but I'm not that convinced.
Rebecca, what do you think?
Well, I think they're going to try, and they're going to give it a red hot go. Obviously the contract can only be amended by agreement, so how successful they are will depend upon the client's appetite to entertain a commercial reset. Certainly, I think that's where the conversation that we've had about construction contracts comes in handy, because if you can demonstrate to your client employer that you've got a good claim, and that if they don't come to the party early, you could litigate it and drag them through the courts. I think staring down the barrel of litigation, years tied up in court and legal fees, hopefully prompts them to engage in a commercial resetting exercise. But again, I think we'll have to see what happens on a case-by-case basis. I don't often recommend to my company that they sue others and that they pursue arbitration litigation, because I think the lawyers win and not many others do. But if that's the only way, then the only way. Okay.
Thank you, Rebecca. I've got a specific question for you, Rebecca. Do you predict an uptake of international standard form contracts in Australia as a result of COVID-19?
I don't know whether that would come about as a result of COVID-19, but I have seen a few projects come online that are using FIDIC contracts. I really think, COVID-19 again is a good sort of stomping ground to try new things, but I think that we're pretty sheltered in Australia. I'd really like to see us open our eyes to other contracting models. I mean, the one I'm watching with interest is the NEC suite, and in particular the NEC4, because it's got these collaborative mechanisms in it that I think our industry would really benefit from. The Standards Australia suite that we use, there's a fantastic report that the Society of Construction Law Australia did in conjunction with the University of Melbourne. It's quite old now. I think it's a 2014 report, but they studied the use of contracts, and like 85% of Standards Australia standard form contracts are amended in Australia. And I just think, well, then why bother? Like, why don't we? And they're not amended for the good. So they're not amended to introduce regimes about collaboration and cooperation and, shared project teams and working together and things like that. So I would like to see the take up of those contracts, but I don't know that. I expect that people, when people sort of get stressed and tense, they fall back into what they know. So I don't expect that we'll see that, but there may be some brave souls who think it's time. Yep.
Okay, thank you. So a question to you both. So is it the view of the panel that governments need to wise up on risk allocation and profitability of bidders to ensure there is a healthy supplier base? Otherwise, they get poor quality and quantity of infrastructure. As one speaker said, a more collaborative approach is required.
I agree. However, I'm not in government. So I think that's this is really a culture issue, and it's been an ongoing theme throughout really the whole of my construction industry career, which is I wouldn't like to say how many decades it is, but it's quite a few. What do you think, Rebecca?
I think I've got two things to say about that. The first is that I agree with you, Jennifer, about the adversarial culture. I don't think we're very good at trusting each other, which is a shame. And Andrew, could you restate the question for me, just so I can make sure I give the two things in response to the question itself?
So is it the view of the panel that governments need to wise up on risk allocation and profitability of bidders to ensure there's a healthy supplier base? Otherwise, they get poor quality and quantity of infrastructure.
Thank you. I suppose one of the things I was going to mention was that I can't remember which government it was, but I read an article recently about the fact that panels of contractors have been established. So you sort of have the tier ones, tier twos, tier threes, tier fours, and governments are ensuring a greater spread of work. The Victorian government did this on the level crossing removal project. So the work obviously to get rid of level crossings and put them underground or above ground, remove them altogether. And they made sure that work was spread to a range of construction contractors. So if the project was smaller, it might not go to a tier one, it might go to a tier two. I think the second thing to say is that unfortunately, government is driven by money. And when I say money, I mean price certainty. So when we start a project, a budget's put up for the project, And it might include some contingency, and that's done so early on, and then everyone's expectations are tied to that figure, and that figure might be set well before government's even engaged with the market and the very people who are going to build the project and know what it's going to cost to build. And it's before anyone's actually gone out on site and done really detailed analysis of what's actually there and how it needs to be managed. So I think it takes a shift in the mind about how we price projects and how we understand projects, and certainly having a Treasury Department set a figure right at this end of the time scale without enough consultation with the people who should know what they're doing it sets you up to fail from the beginning, because there's just not the conversation that needs to occur just doesn't occur. And then the wrong people set the expectation. Like, you've got non-experts essentially pricing a project and then holding everyone to a number that they've developed. Such a contractor thing to say, Andrew.
Thank you. So I think that's the extent of questions. Oh, one has just come in. Frameworks have generally worked well in the UK, but there are research papers which highlight some of the difficulties to watch for. Any views on that? It was a comment rather than a question.
Might leave that one to you, Jennifer.
I have nothing more. I have nothing more to add.
Fair enough. Okay, so I'll now bring the question session to a close, and first like to thank Jennifer and Rebecca for the insightful presentation. From my point of view, it came across very well. You covered a lot of material in such a short time, in a good amount of detail. So I'm quite impressed with how it came across.
Thank you.
So I'd also like to thank delegates. Thank you certainly for those who've logged in very early in the UK and in Europe into the presentation. Thank you for joining us. I'd like to thank also CIB for hosting us. It's much appreciated. And I believe CIB have got an announcement to make now about a forthcoming event.
Thank you, Andrew, and especially thank you to Jennifer and Rebecca for such a great presentation. My name is Mike Beam. I'm the program director at CIB. And we do have an event, our triennial World Building Congress coming up in your hometown, Rebecca, hosted by RMIT in Melbourne. And we're really looking forward to that and hope all the delegates, and there's a strong W113 showing and a lot of collaboration. And I do just have one more little thing to say, maybe if on the next.
Sure.
Just advance one more, and CIB does have a very large breadth of networks within the built environment, and I encourage your delegates to learn more about CIB on our website, and please reach out. So thank you, and thank you for a great and wonderful webinar.
Thank you, Mike.
Thank you, Michael.
Thank you.
Thank you.
And thank you, Andrew, for chairing our presentation this morning.
You're very welcome.